Welcome to meeting number 5 of the House of Commons Standing Committee on Procedure and House Affairs. The committee is meeting today to hear from the Conflict of Interest and Ethics Commissioner, Mr. Mario Dion, on the committee's study to review the Conflict of Interest Code for members of Parliament. Prior to adjourning the meeting today, I do intend to discuss some matters related to committee business. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. So you're aware, the webcast will always show the person speaking rather than the entirety of the committee. I'd like to take this opportunity to remind all participants to this meeting that screenshots or taking photos of your screen is not permitted. This applies to observers as well. Given the ongoing pandemic situation, and in light of the recommendations from health authorities, as well as the directive of the Board of Internal Economy on October the 19th, 2021, and the House Order of November 25th, 2021, to remain healthy and safe, all those attending the meeting in person are to maintain 2-meter physical distancing, must wear a non-medical mask when circulating in the room, and it is highly recommended that the mask be worn at all times, including when seated. All those attending the meeting in person must also maintain proper hand hygiene by using the provided hand sanitizer at the room entrance.
I'd like to outline a few rules to follow. Members and witnesses may speak in the official language of their choice. Interpretation services are available for this meeting. You have the choice at the bottom of your screen of either Floor, English, or French. If interpretation is lost, please inform me immediately and we will ensure interpretation is properly restored before resuming the proceedings. The raise hand feature at the bottom of the screen can be used at any time if you wish to speak or alert the chair. For members participating in person, proceed as you usually would when the whole committee is meeting in person in a committee room. Keep in mind the Board of Internal Economy's guidelines for mask use and health protocols. Before speaking, please wait until I recognize you by name. If you are on the video conference, please click on the microphone icon to unmute yourself. Those in the room, your microphone will be controlled as normal by the Proceedings and Verification Officer. When speaking, please speak slowly and clearly. When you are not speaking, your mic should be on mute. A reminder that all comments by members and witnesses should be addressed through the chair. And I just want to remind us at the previous meeting, which was virtual, or hybrid, we were able to have members of the committee interact directly with the witness by raising comments and responses through the chair. And I would ask that we take a breath between those interactions to ensure, my concerns and all of our concerns for interpretation. So as long as we maintain a good pace, I will do my minimal interjections. But if I do feel that it's getting too quickly, I will then provide some commentary, which if you would like to avoid, now you know how. With regard to a speaking list, the committee clerk and I will do best we can to maintain consolidated order of speakings for all members, whether they are participating virtually or in person. I would now like to welcome Mr. Dion back to our committee.
Friendly point of order, Madam Chair.
Yes.
I think already a friendly one. Madam Chair, may I just ask the clerk for advice on this. Always like to hear your voice for the first few minutes of the meeting, of course, but and I know this is a customary thing. The clerk has advised that all committees do this at the beginning of the meeting. We're 2 years into this. I think we know the rules and clicking the buttons, and the witnesses, for an example, in this case, Mr. Dion, welcome back, has already heard this from the previous testimony, but for your benefit and time, may I suggest that going forward we provide the witnesses in writing what you've just said at the beginning of the meeting, so when the meeting begins, we can get right to it. I will leave it to the committee to decide, but that might be something to consider to help move our business along and get to some more riveting questions today. Thanks.
Brilliant. We will definitely take that offline and have that conversation, perhaps at a subcommittee. Thank you for raising that, Mr. Duncan. So Mr. Dion will be with us for approximately 90 minutes. Then, as I indicated, the committee will conduct some committee business for its future meetings if time permits. Mr. Dion, please proceed with your statement.
Merci, Madame la Présidente, Mesdames et Messieurs, les...
Thank you, Chair. Madam Chair, honorable members of the committee, thank you for inviting me here today. As I said when I had the privilege of appearing before the committee in December, on December the 14th, as an officer of the House of Commons, whenever members call me, they are my first priority. I am pleased that the committee has initiated a review of the Conflict of Interest Code for members of the House of Commons. The code is an important set of rules governing certain aspects of members' activities. It benefits from being examined from time to time. This process will test the continued applicability of the rules and address any shortcomings identified through people who, like myself, have a certain experience gained through administering the rules, as well as by members.
Well before I was appointed to my current position in January 2018, I consider myself fortunate to have this opportunity to, in some way, contribute to the ongoing evolution of this important framework supporting our democratic institutions. The committee has received from the office a list of 6 possible suggestions regarding the code and a selection of possible technical amendments that the committee may wish to consider. These recommendations were developed over a period of the last 4 years since I became commissioner, with the participation of advisors and lawyers in the office who worked with the code on a daily basis. These suggested amendments are aimed at bringing greater accountability and transparency for members of the public. Our first recommendation, or proposed suggestion, if you wish, is to set a baseline minimum amount for gifts and potential influence, that being $30, all-inclusive, in a 12-month period from a single source. Our second recommendation suggests that we strengthen and align the rules of conduct against furthering private interest of friends and family members, bringing it in alignment with the members' bylaw. Our third recommendation would be to prohibit outside activities incompatible with a member's parliamentary duties and functions. La quatrième possibilité de...
The fourth potential amendment involves building coherence within the code, and this in terms of sponsored travel, by considering it as a gift that must pass the acceptability test like any other gift. Recommendation 5 would be to enhance understanding of the code with mandatory training for new members. And finally, recommendation number 6 would be to provide increased autonomy to the office to amend forms and give generalized guidance to help better explain the code's provisions.
Were developed over time through observation, reflection. I would modernize and improve the rules related to gifts and conflicts of interest as they relate to friends and family members, and would better define the boundaries of permissible outside activities for members. They would also require members to spend some time learning the rules set out in the code, as experience has shown that ignorance of the rules is often at the root of contraventions. Finally, if the House deems it useful, one of my suggestions is to provide the Commissioner with additional authority and autonomy to address specific situations requiring general guidance. It's the committee's role to assess the relevance of these suggestions, and I will, of course, respect the decisions of the committee. I would also be pleased to offer my views throughout this review, if you so wish, on any matter that the committee may wish to refer to me. C'est mon rôle, en fait, d'aider le...
That, of course, is my role, to assist the committee in managing the Conflict of Interest Code. So I would be particularly available during this review period that the committee has undertaken. I'd be pleased to hear members' reactions, take questions, and provide explanations to you. I'm a resource for the committee, and I hope that I can assist members as they ponder what needs to be addressed in this review. So thank you, Madam Chair.
Merci beaucoup, Mr.
Thank you very much, Mr. Dion.
First round of questions, and there will be 6-minute rounds, starting with Mr. Broussard, followed by Mr. Turnbull, puis Mr. Tellier, and then Ms. Blaney. Mr. Broussard, the floor is yours.
Thank you, Madam Chair, and thank you again, Mr. Dion, for being here today. And I also want to thank you and your office for the response. I've made several requests of your office, and those responses have always come back in a timely manner. So I want to thank you for that. I want to focus on the recommendations because they are consistent with your appearance here in December. Now I know that the devil is in the details, and these are very high level, and I'm sure my colleagues in subsequent rounds will have questions related to them. But I want to focus specifically on recommendation number 3, where you say prohibit outside activities incompatible with a member's parliamentary duties and functions. I'm just wondering if you can expand on that, please.
At the present time, under Section 7 of the Code, it is Section 7 says that nothing in the Code prevents members who are not ministers or parliamentary secretaries from engaging in employment or in the practice of a profession, carrying out a business, and so on and so forth. So there's no prohibition against continuing or initiating a new activity, a new business, a new profession, and so on and so forth. Although there were very few in the last legislature, there were very few MPs who were carrying out a business or were employed elsewhere or involved in the practice of a profession. We find that from a philosophical point of view, considering the nature of the work of an MP nowadays, the level of activity and so on and so forth, that it might be appropriate for the House to consider whether this rule is still adequate in the circumstances, because it does give rise to a stronger possibility of conflict of interest, of course, if you operate a business or if you're engaged in employment while being at the same time a member of Parliament.
Thank you for clarifying that. My next question relates to digital media. We've seen recent news reports of the leader of the NDP, for example, receiving a gift of a chair, and this speaks more broadly to the influence of digital media and the platforms that members of Parliament have, in some cases hundreds of thousands or millions of followers, and they could use those platforms for all intents and purposes, commercial purposes, as we saw recently. And I know that your office has been made aware of that situation. You didn't address the digital media aspect and the role that MPs play, and that could be related to digital media influencers, having friends, families, spouses who are deemed as digital media influencers. Is this something that the committee should be looking at, Mr. Dion?
I think the rules as they are currently written in the code would adequately cover those situations. The rules do not focus on the medium. The rules focus on the behavior. So Section 8, for instance, says that a member shall not act in any way to further his or her private interests or those of a family member, or to improperly further the private interest of a private corporation. So it doesn't matter whether you do so with a megaphone on the hill or you do so in a letter to someone or in a telegram or through Facebook. It's all the same. The medium does not matter. The degree of influence, of course, could be variable depending on how many people you actually reach with the medium, but the contravention itself would arise irrespective of the medium. So that's why we haven't addressed it. We think the code is nimble. The code adapts to technological evolution. At least that's been my experience in the last 4 years.
Mr. Dion, the last time you were here, I asked you a question as it related to public confidence, and you mentioned at the time that there were several polls that were attributable not only to the code, but also the Conflict of Interest Act, and that the confidence that people have in their governments generally, both in Canada and abroad, is diminishing. The challenge that we have right now is that when a member violates the code, the public perception, real or otherwise, is that it's a very limited response that's available to us. In other words, it doesn't really deter $500 fines or whatever is deemed by Parliament, whether it's an apology that isn't acted on. Is there a need to review a more substantive response to a violation of the Code of Conduct on members as it relates to either financial penalties or other penalties, in your opinion?
I'm not sure it's for to really assess the situation. There hasn't been a single one in the last 4 years where to other types of penalties. So we've had a number of inquiries involving members of parliament, and there hasn't been a single situation where I thought that the existing regime was not sufficient to properly address it. Whether there is a demand on the part of the public for more access to more penalties, I think there is. But in my opinion, at this point in time, it hasn't turned out to be necessary. So I'll leave it to parliamentarians to determine, in order to have a credible response in principle, whether it's necessary to look at possible penalties under the code and to increase them, or to give me more authority vis-a-vis recommending such penalties.
About 35 seconds, Mr. Broussard, and remember, through the chair.
Chair, and through you, what would be, in your opinion, what could be a good deterrent, or what could parliamentarians offer as a deterrent, Mr. Dion?
I think suspension of one's duties for a few days or a few weeks in labor law has proven to be an effective remedy. So maybe that's a possible one for a member of the House of Commons who would contravene in a very serious way to one of the provisions of the code. That's one that comes to mind, basically.
Thank you, Mr. Dion. We'll be moving to the next round with Mr. Turnbull, and I'll just give a reminder to all members to address comments through the chair and not directly to our visitors. Thank you, or witness.
Thank you, Madam Chair, and thank you through you to Mr. Dion for being here today. Really appreciate the report and the recommendations and some of the thoughtful remarks I think provided today. I have lots of questions, but I do appreciate. I know that you're putting forward, things, Mr. Dion, that I think have the best intentions of improving our overall conflict of interest code for members, also maintaining public trust, etc. There's many values that I think you hold strongly, and I appreciate that. So, with regards to recommendation number 1, which is setting a baseline minimum amount for allowable gifts, I'm just interested to understand a little bit more about your rationale for wanting to change that threshold from 200 to 30 per year. I'm struggling a little bit in my mind to understand the rationale behind, why $30. What really, like, even a $200 gift from my perspective, usually, it would be tough to assume from a reasonable person's perspective that would influence a member of parliament's exercise of their duties, in my opinion. But what I would like to understand is how $30 would change that. Can you explain that to us?
Chair, I'm pleased to. What we intended to recommend was quite different than what the member has described, basically. What we are recommending is that if a member of parliament receives from a source, a company, a person, an entity, a lobbyist, a gift that is valued at $30 or less, that there is no need what I mean by somebody as being given to the member in order to influence him or her. $30. So it's based on practicality. I don't think anybody would think that a member of parliament can be swayed with a meal, with a sandwich, with a coffee, with a drink worth less than $30.
Point of order, Madam Chair.
Yes.
My apologies, Madam Chair. The witness cut out at a very key point in his testimony, so we didn't actually hear the response. Is it possible for him to repeat? He was talking about that threshold, the $30, and what would actually happen, and we missed out on the actual response. Thank you.
Point made. Thank you. Mr. Dion, can you rewind a little bit? And we'll add that time to Mr. Turnbull.
So our suggestion in the first recommendation is to say black on white in the code that if an MP receives a gift worth $30 or less, all included, from a source, no more than once a year from that source, then no need to analyze anything, basically. It's perfectly acceptable. The MP gets the gift. The MP doesn't have to even think about it. It's fine because it's part of what is required, for social relationships to take place. It's perfectly appropriate for an MP to accept a coffee from a lobbyist if offered to him at Starbucks, for instance. So just to stop wasting time, trying to explain to people that it's okay to eat 2 shrimps at the reception instead of 5. A gift of $30 is acceptable by definition. No need to ask any question. We intend to affect in any way the threshold of declaration, which is currently at $200 or more. Our aim is to simplify and make more practical the small gifts.
Okay. Thank you, Madam Chair, and through you to Mr. Dion. I appreciate the response and appreciate that. I think I misspoke when I was asking my question. So I did understand the intention, and still not quite clear on why 30 versus 50 versus 150 versus 200. It seems a little bit arbitrary to me. So that's really what I'm looking for the rationale on.
Madam Chair, any line is arbitrary. My predecessor had picked $30 several years ago, so I thought it would be safe to pick the same line considering inflation. That's all there is to it. It could be $50, it could be $45. Any line, most lines are arbitrary in life.
Okay, thank you, Madam Chair. Through you again to Mr. Dion. I'm interested in just having a little bit more clarification on recommendation number 2, which is to strengthen and align the rules of conduct against furthering private interest of friends and family members, which I think is important to all of us. I think Mr. Dion is asking for an expanded definition here of family and to also include friends' private interest. I'm wondering whether that would make it so that friends and extended family would have to do disclosure. Whether Mr. Dion would see that as feasible.
Madam Chair, our primary aim in this recommendation would be to make it clear that in conflict of interest matters, you have 3 categories of people. First category is yourself, your spouse, and your dependent children. The nucleus, what I call the nucleus, the closest people to you, including yourself. Second category would be friends and other relatives as defined in the members bylaw. Okay. So a second circle of people where you have to look more carefully at whether a conflict of interest is likely to arise. And the third category is strangers, anybody else, basically, for whom there is no reason to believe you would want to foster their interests. So that's what we're recommending. Just like in the Conflict of Interest Act, the friend is at the same level as the relative, and the relative is more than the nucleus in the Conflict of Interest Act. And all I'm suggesting is that maybe the House would like to consider doing the same thing vis-a-vis members of Parliament and the need to avoid conflicts of interest.
And that brings us to time. So we will pass the floor over to Mr. Thérien. Mr. Thérien, à vous la parole pour 6 minutes.
Mr. Thérien, you have the floor.
Thank you, Madam Chair. Can you hear me clearly? So I have to give my greetings to the chair, to the committee members, and to Mr. Dion. I'm sorry I had some problems, some technical problems. And we will go through the chair to ask questions of the witness. Even at my age, one can learn that. So you have written at some point, over a period of 12 months, gifts have an advantage of a provenance that are whose total value is $200 or more. When we're thinking from the same provenance, so let's speak about that from the same source. I have a business, or I have people who have common interests who create a group and each gives me $30. That can come to quite a high number, depending on the number of people who will decide to offer gifts. So at that point, one might find oneself in a situation where these gifts, even though they're less than $30 per person, the amount can go well higher than $200. So I'd like to have the explanation, but also ask the following question to the witness. Should we not, perhaps, and I'm asking the question to Madam Chair, should we not better determine what the same source is? Is that defined, and could that be improved so that we could avoid this kind of problem, if there is such a problem in practice? Maybe our witness had already anticipated the situation. I'd like to have this information. Thank you. In the current code, and in our experience, we always take for granted that a physical person, the provenance is the same civil person or moral person. So one individual is one source. There can be 4 individuals from the same family who each give a gift. We look at the value of the gift given by each individual, not the total amount, because these people all have a legal status that's defined. That's how the code is being interpreted currently, and that would also be our recommendation. Thank you, Madam Chair. And I think I can thank the witness. Thank you. Has such a situation already occurred in the past where you really had to look at the source of the gift and saying, yes, I think there's been abuse in that case? No, it has not happened to my knowledge since I've been there. There are far fewer gifts that are given that we might imagine, and I've never seen this type of situation. When we're talking about gifts or amounts of money less than $30, I always have a question in mind. Sometimes we can receive gifts that we deem to be worth less than $30, but they are gifts that have a huge value, and we don't know how to determine that value. So we told ourselves, well, it might be worth $15 or $20. I'm not going to go see the ethics commissioner about this. But because of ignorance about the value of things, we can find ourselves with articles that have a very high value. First of all, what happens if I accept a gift that I thought to be worth less than $30, and then later I realize that it has a very high value? What would happen as regards to myself? And would you say that in that case one should go see the ethics commissioner even though we have thought that it's worth less than $30? I would say, Madam Chair, that if there's a doubt in the member's mind, you can always consult us. It's never a problem for us. And we're talking about market value, because we could try and determine that with you to eliminate any doubts you might have. It's the market value. There are some things that are difficult to evaluate. And when we look at the Antiques Roadshow, we can confirm.
If you watch Antiques Roadshow, you know what I mean. Sometimes you think it's worthless and somebody else knows that it's worth a lot, or vice versa. So I think it has to be something about good faith. If you think that you've gotten an antique Greek statue and you think that it's worth less than $200, that might be a little more difficult to prove that you really believe that it's worth less than $200. So there's good faith. Check with us. Don't hesitate. And we will try to assess the market value. Very well. Because in my previous life, it happened to me. It wasn't something that was valued high, but I did wonder about it, and I had to have it assessed because you have to be vigilant. As Mr. Dion has said, there could be objects that are worth a fortune, and we don't know. Now, at one point, you were talking about customary standards of hospitality. How could you establish a financial value for a customary standard of courtesy or hospitality? Could you give me some examples, please? Well, it's all a bit vague. Madam Chair, even with the same country, this varies depending on the times. For example, let's say you're giving a talk at a conference and you're given a bottle of wine. Well, it's easy to check on the value of that bottle of wine. There's a liquor commission website, depending on whatever province you're in, and you can check the price. So if you're given a $22 bottle of wine, no problem. But what if you're given a $426 bottle of wine? It would be difficult to claim that that is a standard, customary standard of hospitality. So what seems to be the common practice? It's highly arbitrary. And that's why, if the commissioner answers you, if the office answers in an email that it's okay and you can accept it, great, you're covered, you're protected. That's perhaps the best way of proceeding. As soon as there's any doubt, consult the office, get a written answer, and you're protected. Very well. Mr. Terrien, that completes your 6 minutes. Thank you very much, Madam Chair. So we'll now continue for 6 minutes with Madam Blaney.
Well, thank you, Madam Chair. And through you, I'd like to first extend my gratitude to Mr. Dion for today's information and for his well thought out recommendations. I just have a few questions. One of the questions is around receiving gifts. We've had a lot of good debate about it, but I just want to recognize that for some gifts, there's a cultural sensitivity to receiving those gifts. So, I have a lot of Indigenous communities within my region. A big part of the culture is to share things, to demonstrate that you've heard their words. It's not obligating you to do something. It is recognizing and having the member carry that as a gift that reminds them of their hearing of the truth of the community. And I also know in a lot of Asian communities that can be the same. So I'm just wondering, in the discussions that you've had, have you looked into how to review that component, because there's some very sensitive cultural processes that could be very offensive, and when you're in a leadership role you have to think those out. So I'm just wondering, in the work that has been done, has that component been brought forward, and do you have any recommendations you'd like to add that would help us navigate that more effectively?
So, Madam Chair, we have indeed on more than one occasion, on several occasions since I've been there the last 4 years, come across situations involving particularly Indigenous peoples, where we receive some representations. I used to be involved myself with. I had several dealings with Aboriginal people back in the early 2000s when I was at Indian Residential Schools Resolution Canada. And we've secured some clear legal advice, and it's perfectly appropriate to consider when we say in subsection 14.2 of the code, normal expression of courtesy or protocol. Of course, that's variable depending on who the donor is, what the culture of the donor is, and it's acceptable to take that into consideration, and it could have an impact on the acceptability of the gift. And we would never force an MP to return a gift unless it was clearly abusive, even under those protocols and rules of that particular community.
Thank you, Madam Chair. I'd like to thank him for the answers through you. I also am just curious about your recommendation number 3, which I think is really interesting to think about how to make sure that what the Member of Parliament is doing outside of their parliamentary duties is compatible. I'm just curious if you could talk a little bit more about if there's been any analysis done about what professions might be a little bit more acceptable, or more other professions that might be more concerning. For example, if you are a Member of Parliament and you are able to sell yourself as a public speaker, an online content creator, social media influencer, or brand representative, I think there could be some interesting conflicts there that we need to address. And I'm just wondering, is there any interest from the department in fleshing out the type of work an MP could carry out while they are a Member of Parliament? And perhaps even in what context?
Chair, we would, if our recommendation was to be adopted, accepted, we would be pleased to provide some draft guidelines for trying to determine criteria, which criteria would be used and it could be in the code themselves as well, those criteria. There are some professions which basically have no bearing on the role as a member of parliament. The one I thought about was if you are a veterinarian. I've always had trouble pronouncing that word, but if you are an animal doctor, let's put it that way, I think it's far less likely that there could be conflicts than if you're practicing law, obviously. And in practice, the situation that we have had mostly is either business people who have large businesses they operate, and very often legal practitioners as well, who have been MPs and legal practitioners at the same time. And again, it's a very small number. When I first started, we had 12 MPs who had declared such an activity out of 338. So we're not talking about a large number. I was concerned about a few of these MPs who I thought were playing with fire. They were coming close to the line by practicing. So I thought the House may wish to clarify that in the code, that if it's incompatible in the view of the commissioner, then it should not be permitted.
1 minute left.
Thank you, Madam Chair. And I just want to, through you, Madam, let Mr. Dion know that every once in a while, I don't know if the clerk can look into this, is you are clipping out just shortly and we're not hearing. So I just wanted to bring that to your attention. I haven't lost the content of anything yet, but it has happened a couple of times. I guess the other thing that I have questions is around sanctions. I'm just wondering, how does the commissioner determine appropriateness? So we've seen examples of small fines for what I perceive as pretty big failures to be transparent. And I'm just wondering, should sanctions include any expenses incurred by the ethics commissioner? So if a member doesn't do their due diligence, make sure that that information is there for you to look at, or the department to look at, should there be some sort of reflection of that in terms of their fine?
Madam Chair, there is always a great deal of confusion between the code on the one hand, which is applicable to MPs and to all MPs, including ministers, and the Act, the Conflict of Interest Act, which is only applicable to other non-elected officials, okay, as well as ministers. So my point is there is no sanction currently set out in the code. I have the power to recommend a sanction in the code. The House is the only authority that can sanction an MP. It's available by way of sanctions. And since the code was adopted, the only sanction that was imposed was an apology, basically, in a few cases. It never went any greater than that. There is no list in the code. So each case has to be weighed on its own merit by the commissioner on the one hand to determine whether I should recommend something. And then in my report to the speaker, I would make a recommendation, and then it's up to the House to decide what to do vis-a-vis the contravention that is found in the report.
Thank you, Mr. Dion. I'm going to continue to round two. We will have 5 minutes to Mr. Duncan, followed by 5 minutes to Mr. Fergus. Et puis 2 minutes et demie pour Mr. Tallien, 2.5 minutes to Ms. Blaney, 5 minutes to Mr. Viss, and 5 minutes to Ms. Sahota. Mr. Duncan, the floor is yours.
Thank you, Madam Chair. Through you, Mr. Dion, I just want to start actually on a positive note. I will say in my dealings, your office, the customer service level has been excellent. My advisor, very timely responses, very clear answers, and that is much appreciated. I want to maybe ask on recommendation number 4, one of the things I think our committee needs to tackle is the dealing of paid internships. Would I be accurate in saying, Mr. Dion, although it's not specifically addressed in there, when you talk about building or working with the code for sponsored travel, that paid internships would be considered kind of a comparable issue as that in your ruling or your recommendation on that?
No, in fact, a few years ago, I have ruled that an intern constitutes an advantage. An intern is like a gift. The value of the gift is what the intern gets paid by a third party. Accepting an intern is like accepting a gift. And several MPs have declared that gift. It's been published in the public registry. And I've also ruled that an MP shall never accept a gift by an entity which is registered to lobby the House of Commons, because a gift from a lobbyist is, by definition, unacceptable. And thirdly, of course, any intern through a parliamentary program is perfectly appropriate, of course. We're talking about outside entities providing interns.
In building further to that about third parties, because where do you get the degree of separation a little bit? So for an organization perhaps that would have a paid internship program that would have that would lobby the House of Commons, but then what about an organization that is considered a not-for-profit but receives funding from organizations? You don't necessarily have that disclosure. Where does the line go on that in terms of that level? Because there could be a degree of separation just through the funding model, the mechanism of how an internship program would be set up. Would that be fair that it gets a little more complex there?
Yes, it does, and we've had a few situations where we have analyzed in conjunction with the MP whether the gift was acceptable or not acceptable, considering the structure, the funding structure as well. That's a fact. It's a clear factor in determining whether it's acceptable.
For that, and I think this is something as we consider recommendations and look at this, we have to get right, because I see the value of internships in Parliament and around the Hill here, and bringing young people in and giving them experience and wanting to get it right. I mean, so I look forward to some further discussion around that issue. One of the other things I wanted to talk about was the definition of friends in that issue. I can understand the intent of it, but the enacting of it could be tough. And I look through the analyst's document to us today that talks about the definition that's placed in your website. Individuals who have a close bond of friendship, a feeling of affection, or a special kinship with the public office holder. Mr. Commissioner, I would have a problem that I feel I have a lot of friends, or a lot of people feel they're my friends, in the work that's going on. Family is one thing. You're a cousin, you're a cousin. You're a sister, you're a sister. Mm-hmm. I like to think in our role, a lot of people think, and I like to have a lot of friends, and people think I'm a friend, but that's a lot harder to define. I respect the fact of an attempt at a definition or interpretation, but it gets into a really gray area where, is that traveling together once a year? Is that sitting together at a community event? Is that being in a wedding party? The definition of that to me is still very vague, and again, the optics or the intention of it versus the enactment. Do you have any plans to try to define friends more definitively when we're talking about this?
No, in fact, sorry, Madam Chair, we looked at this. It is very difficult to define. And again, as mentioned in an earlier question, there are cultural differences as well. The concept of a friend varies from one culture to another potentially. And we each have our own definition of who's a friend. Some people feel they've had 2 friends in their lifetime, and some people think they have 2,000 friends, So it's very, very flexible. In the Morneau 2 report, I had to look at the issue. I applied the criteria developed by my predecessor, which you just read out. And it has to be done on a case-by-case basis. So in practice, what an MP could do is discuss the relationship with office, and we would essentially make a determination whether this person is or isn't a friend. In case there is a complaint, we could determine in advance whether somebody would be considered to be a friend according to these criteria. And again, the MP would be protected. But I'm afraid it's impossible to come up with a complete, forever applicable definition. It's absolutely impossible to do that because there are millions of permutations.
Mr. Duncan, that brings us to time.
Oh, thank you.
Sorry, I didn't give you a warning. I didn't want to interrupt. Mr. Fergus, 5 minutes to you.
Merci beaucoup, Madame la Présidente. Puis j'aimerais encore.
Thank you very much, Madam Chair, and I'd like to thank the Commissioner for being here with us today, and for his evidence and the document with the recommendations that we should consider. Mr. Dion, I have to tell you, quite frankly, I think that we could spend a lot of time to explain to look at the consequences of several of the recommendations that you have presented us. And that brings me back again. I know we had the opportunity to discuss this in December, but I will repeat it in order to seek some clarification. When I was working in the private sector, I was the director of ethics for an association of companies. And one of the things that we realized very quickly, I was the first person to hold that position for that association. And we had arrived at the conclusion that it was so complex to have a code that was as thick as a phone book with all sorts of regulations. And I know that in recommendation 5, and you tried several times to encourage members to attend training about the code's application. I was wondering if you thought of doing something that's never been seen before, as we did in the private sector, and instead of having such a huge number of regulations to cover all activities of the members, have you thought of proposing something like the 10 Commandments of the action that we should take as members to in order to act or behave in an appropriate way, something like guidelines? Well, not guidelines in the sense that you've already stated, but a kind of rule. You have to behave in a way that does not give the appearance of a conflict of interest. Maybe it would be better to have something that's simpler, and it obliges the deputies to engage in reflection on the matter. And also the members can contact your office and have a conversation to reach some conclusion. Because Mr. Brassard asked, what's the difference between a $30 meal and a $32 meal? It's the intention behind the meal that's most important, rather than the amount. So I'm sorry, I've spoken too long, so please take all the time you would need to answer this question. Thank you, Madam Chair. The current code has clear and simple rules. Some leave a lot of room to interpretation, but most of them are clear and simple. And a lot of work was done before 2004, since 2004. I don't think we could have something that would be much simpler than what we currently have. We would have to be thinking in a completely different way. But in the British-inspired regimes, Westminster parliaments, this is the kind of code that we're used to, and it works. And that's why I recommend mandatory training, in order to get people to forget details. People have a natural tendency to focus on details, but rather focus on general principles. So in the training, I'd like to explain general principles. So the members should really know when to consult us. So we have to, they have to develop this reflex. Oh, there's a problem, I will consult you. And it's impossible for a member to understand the regime as well as someone who's been working the field for 15 years. So we find a solution, we send it in an email, it protects the member, and it works. So they have to develop that reflex when there is a problem and try and consult us before doing something rather than afterwards. Thank you, Mr. Dion. And now Mr. Terrien has 2.5 minutes. Thank you, Madam Chair. So I'd like to come back to the sources of gifts that we can receive. You did answer, but I'm coming back because I didn't understand completely clearly. Let's say that over the course of the year, I receive gifts 7 or 8 times, and I go and see Mr. Dion, and I say, well, look, I behave properly, Madam Chair. So I go see Mr. Dion and I say I'd had 7 gifts over the course of a year. Will Mr. Dion automatically check to see if these gifts might actually have come from the same source? Yes. And so, Madam Chair, as I was saying earlier, there aren't so many situations where gifts are offered to members of parliament. Well, I don't have any. So say we have 138 people who receive maybe 100 gifts per year. So it's very unusual that members of parliament receive so many gifts. So we look for the source. So, for example, a journalist might get interested in a member who's receiving gifts from sources that are interconnected to each other. For example, companies associated with each other. That's why we have to identify the giver so we can carry out an analysis. But in practice, it's not necessary to do this because there are very few MPs who receive more than one gift. So if I've understood Mr. Dion does this systematically with no problem. I'm asking these questions because I'm not aware of the situation. I've never done that kind of work, so it's difficult for me to grasp everything as well as Mr. Dion does. So I will do something. I think Mr. Dion has a very difficult job to do. I think that he must feel a lot of pressure because even if he writes an ethics code that's as specific as possible, there are still many gray zones. For example, who is part of the family? See, I see that the family has been, definition has been broadened since we heard him. Now we're talking about friends. So what's a true friend? So not say, like at the Charbonneau Commission, that a chum is a chum, or a buddy is a buddy. But so he must feel this, does he feel this pressure in assessing these gray zones? And can he be criticized even if he judges that it's okay to have? Will there be people who say, no, that doesn't make sense because there might be partisanship here? So we don't have any more time. So 15 seconds, Mr. Dion. Yes, I do feel pressure because the person who's responsible for conforming to the code is the member, not me. That person is the member, but I am the advisor. I'm a bit like a judge. If they don't like my decision, I'm there till January, whenever it is. Madame Blaney.
Madam, thank you, Madam Speaker, and through you. You know, I've heard clearly from the Commissioner that there is a lot of room for improving the confidence of Canadians in their public institutions. And I think that's something that as members of Parliament, we should always be having vigorous conversations about. I'm just wondering, through you, Madam Speaker, if the Commissioner could talk about if there's any other tools or resources that other commissioners have in other jurisdictions that have the power to enforce some of these standards or would potentially be recommended to build up that public trust within these institutions.
Madam Chair, in Canada, I believe we at the federal level have at least as much of and sometimes more tools than they do have at the provincial and territorial level domestically. We have not done, since I've been here, an international comparison to see how in 2022 the ethical rules governing elected officials are applied in comparable countries. We haven't done that. And the committee might wish to consider doing that in its review. And we would be pleased to participate and assist in doing that, but we haven't done that. And they do evolve. France came up with a new institution 2 years ago called La Haute Autorité, the Autorités Publiques. Very innovative approach, and I frankly have not had time to study how they do things since then. One example. Britain is reviewing its current approach. The United Kingdom is reviewing its current approach vis-a-vis the same question as well.
Well, thank you so much for that. I think it is something we should be looking into. I'm also just curious, the last time that we were speaking together through the chair, Commissioner, we talked a lot about training and the importance of training. Of course, we were seeing a lot of new MPs come into the office and they were doing a lot of training. And I understand that one of the gaps, of course, is that there isn't a formal training process. So I'm just wondering two things. What do new members need to be provided with in terms of information upon assuming their role to ensure full compliance and understanding of timelines? And then the other part of that question is, what kind of updates do you think MPs might need to have in terms of compliance as they go through their years of serving?
We are at time, but Mr. Dion will give you.
What I have in mind is the fundamentals of the code that would be explained to MPs upon being elected for the first time, no more than 2 hours. And then if any significant change is made to the code or the interpretation of the code, we would have refresher training for MPs available online, everything online.
Excellent. Mr. Duncan, the floor is yours for 5 minutes.
Thank you, Madam Chair. Through you, Mr. Dion, one of the kind of gray areas I feel that is often avoided for being, maybe for lack of a better word, a can of worms, is, Mr. Broussard was talking about this earlier, is our the digital influence or our digital work. So for an example, I go to my community and use the hashtag or tag a business in my community that is seen by thousands of people, perhaps generates interest in their page and so forth. And we've got into accepting or promoting gifts or linking, promoting charities and so forth. Do you see yourself making further black and white declarations of what would be acceptable on social media for members of Parliament?
We could try to develop something like this. It could have to be submitted to the committee and approved by the committee. But of course, we would be pleased to do so because there is a too much uncertainty at this point in time as to appropriate behavior.
I think it's something we have to. Sorry, I can hear you.
Do not focus on the rules. Do not focus on medium, but we could illustrate how the rules would prevent somebody from doing something and would allow somebody to do something else using these media. It's not black and white. It depends on the facts of each case.
And I think as we evolve in the digital age, it's becoming more and more of something that where, again, we were talking about influence or promoting different factors, getting some clear rules on that. One of the other challenges, for lack of a better term that I have, is an evolving conflict of interest, perhaps. And I'll think for Nick's suggestion, if I'm at a local business over the years, and I do this commonly, we'll tag a page of a business or a charity. Several years down the road, I decide I'm looking for a new venture and happen to be employed by that business. Does it later become, a conflict of interest then that I had shared at some point, and how that goes? So I'll maybe just leave that where I'd be interested in your further thoughts of how we can make digital rules and some flexibility. There's two aspects of a conflict of interest with the business, and there's also the tagging and the going back and forth between a member of Parliament and then at election time being a candidate. So I'd be interested, and perhaps we'll be asking for your written thoughts as we get to a draft study on that. The other question I just have is on recommendation number 3, as you talk about separating, the work of members of Parliament and outside income or work. Could I ask for a clarification? You mentioned there's a few MPs, obviously you're not going to name names, but how many are we talking about that are impacted by this currently based on your recent filings or discussions? I don't need an exact number, but maybe a range just to give us a better context.
The last number I saw, Madam Chair, was 12 members after the 2015 election. After the 2019 election, I did not seek a number, so I don't have a number. And of course, although we've received, and I'd like to thank all MPs for doing that, 99% of the MPs provided the necessary information for initial compliance to take place.
Point of order, Madam Chair. Just after Monsieur Dion had said 99% of MPs, the video had cut out, and I'd just like to make sure I understood exactly what he said. Thank you.
Are not compliant.
Mr. Dion, if you can please rewind, and we'll give that time back.
As of yesterday, 99% of MPs have now sent us the necessary documents to proceed to initial compliance. and close to half of the MPs have now completed the process completely after their election. So I'm quite pleased with those results, but I don't have at this moment how many MPs out of the 338 have outside activities under Section 7 of the Code. I don't know that at this moment.
May ask through you, Madam Chair, that we can perhaps get that number to the analyst to consider in our draft report. I think the context of the scale is important on a lot of these things. For sure, it's an issue. The scale of the problem for Canadians, I think, would be important to know. And maybe ask for a clarification or your views on this from a conflict and an ethics perspective. When it comes to extra work, is your concern more the time of work, for example? I'm not a lawyer, but if I was, is your issue the time that they're spending working as a lawyer when you're saying members of Parliament, the rule today? Is it because of the time commitment of member of Parliament? And then secondly, or is it an income perspective? And I think my point to that is that there are several people, perhaps boards of directors that go through where there's an income that comes from that with very little time. So what's your view on income versus work being the issue at hand on that recommendation?
Mr. Dion, the remainder of the time to answer.
So, Madam Chair, and my key concern is limiting occasions where conflicts of interest might arise. So when you have an employer, of course, the employer becomes somebody you care about a little bit more than you care about people you don't know. That's one of my chief concern. And time as well. I find it hard to imagine that somebody could have a full-time job and be an MP at the same time, as has been the case in the past in a very limited number of cases.
Thank you. Ms. Sahota, 5 minutes to yourself.
Thank you, Madam Chair. And I agree, would be very difficult to be a full-time MP and to have another full-time job on the side. I mean, all MPs are full-time, but a full-time job on the side nonetheless would be very difficult. A really easy question to begin off with. Your recommendation number 6, part of it is to be able to give, have more autonomy. To change forms, I can understand, but to give generalized guidance to help better explain the code's provisions. Is there something preventing you from giving generalized guidance at this point in time?
Section 26 of the code, Madam Chair, limits me. I can only issue general guidance if it is taught by an MP. So I couldn't this morning, for instance, issue a guideline on use of Facebook, use of hashtags, for instance, and promoting the interest.
Point of order, Madam Chair.
Yes.
My turn for, there was another glitch again. If the Commissioner could restart, his answer would be appreciated. Thank you.
We're going to...
Would this count against my time?
No.
I've got lots of questions. Thank you.
Mr. Dion.
Section 26 currently restricts me in issuing any general guideline to situations where an actual MP has asked an actual question about the precise issue I want to deal with. So I cannot speculate that an issue might be of interest until such time as somebody asks me a question. I have no authority to issue guidance.
Okay. Going back to the issue of prohibiting outside activities that are incompatible, you had stated before, from your comments before, I'm led to believe that in this case, you would not be prohibiting all outside employment, just ones that weren't, ones that weren't acceptable according to the commissioner's thinking or understanding or whatever. Would being a director of a holding company that was holding real estate alone be considered something that would be incompatible, or would that be compatible? And then I know you gave the example of the veterinarian as well, but I think that's probably less common. And something like real estate holdings is much more common.
So, Madam Chair, I'm pleased the member used the word incompatible because that's what I have in mind. It's not appropriate, it's not desirable, it has to be incompatible. And the burden would be on the commissioner to determine that why it is incompatible. Facts are so important that I would not venture an answer today as to what's incompatible, what isn't. I would have to look at each case. And because we have a limited number of these who have outside activities, it's entirely possible for me to do that.
Okay, thank you for that answer. My next question is something along the lines as well. You had, I think it's great that you're also limiting the amount of things you have to look at. So the threshold of $30, anything under that would be a go. Can you give me an example of what would be over 30 but under 200 that would be problematic in your opinion, and an example of something that wouldn't be, that is between the over 30 and under 200 amount?
So if a member who is currently a member of a House committee reviewing legislation, for instance, I'm picking an example. So the member is currently a member of the House Committee on Agriculture. A bill is coming up. Everybody knows a bill is coming up to regulate the milk industry, for instance. And the member gets a painting from a milk producer in her riding worth $179. I would recommend to the member that she returns the gift, considering the imminence of her having to be involved in discussions and decisions, having to vote, basically, on a bill that could affect this person, this donor. That's one example. When there's a connection, past or future, likely to happen in the future. Of course, I cannot predict who will be a member of which committee 5 years from now, but when you actually know something is likely to happen, then there is a potential conflict that has to be avoided, and the gift should not be accepted.
One minute.
Thank you. Thank you, Commissioner. My last question is regarding the expansion of family. This is interesting to me. I come from a big family. I was doing the calculations loosely right now. If I was to count, you include in-laws and siblings, but you say it goes beyond that. If you were to include first cousins, on my spouse's side, I have about 80 aunts and uncles and first cousins, and on my parents' side, probably a little under that, somewhere around 75. How some are estranged, some are very close. So once you put this out there, that this is a part of the code, media is quick to pick up on things that, you know, they may perceive to be a conflict. And by the time you yourself can even make a decision on such a thing, you know, a member's reputation can be ruined when they had nothing to do with a person receiving some benefit that perhaps the member has never even spoken to in 20 years. So how do you view situations like that? How do, you know, this expansion of this definition from practical purposes seems a little troubling to me as a member. I think it looks good on the outside, but in practicality creates a lot of difficulties.
We are at time. Mr. Dion will give you 15, 20 seconds.
Maybe the committee should look at Statistics Canada data as to whether you are in a classical average situation. I don't think you are, but and how many people would be caught by this definition on average, you know, if we take Canadians at large at this point in time? I think it's far less than the numbers you've given us. But
thank you. Mr. Duncan, 5 minutes to yourself.
Thank you, Madam Chair. Through you, Mr. Dion, to build, just going back to the job, just to get a clarification on that again, are you ruling out or recommending a full, like if it's a full-time job or it's any other employment income while a member of Parliament? For a suggestion, yes, I would agree completely that you couldn't be a full-time lawyer and a member of Parliament at the same time, but you might have time to practice one day a month, or in the summers if there's when there's a longer recess. So are you saying banning any employment income at all as a member of Parliament? Can you just clarify that between full-time, part-time?
No, in fact, Madam Chair, it would be the other way around. It would be permissible unless the Commissioner determines it's incompatible. So it would be perfectly okay for somebody in the summer, when the House typically adjourns for 2 months, to have an activity, no problem whatsoever. It's hard, and unless, of course, there is a conflict of interest involved. No, I wouldn't. And the focus is not on revenue. The focus is on occupation. Is it actually possible to do both at the same time?
Thank you for that. To go maybe to get you on just your thoughts on this, and Ms. O'Hoda talked about this, the size of the family. We're talking offline here, talking about the size of our families and cousins and second cousin twice removed, and the whole thing of where the line goes. But can you maybe talk about the differentiation or the impact of a conflict of interest between members of parliament and cabinet ministers. I think there's a big step there or a difference when we're talking about the size or the ability for a conflict. They still exist, don't get me wrong, but perhaps when we talk about some of these other levels going further, me providing a communications contract to a friend in my hometown that does great graphic design versus a cabinet minister awarding a contract to a friend for a few $1 million. Can you just talk about that, maybe of how there could be a differentiation depending on your level of influence as a member, like, for example, cabinet?
It's Madam Chair, it's next to impossible to try to encapsulate an answer on something like this in a few seconds. Of course, the role of MPs is very different than that of ministers or senior officials. Their decision-making ability on their own is much more limited than it is for these people under the Act. But there are situations, nevertheless, where they find themselves discussing or voting on something which is not of general application, which could benefit a friend or a relative. That's what I have in mind. Most bills deal with the totality of Canada's population or very large segments of the population, but some do favor some people more than others. That's what we're focusing on. If you have a relative, if you have a friend who would be positively affected by a measure on which you have to consider or express yourself on, you should stop and think about that. There is a provision in the code in existence saying if you find there is a conflict, you should declare the conflict immediately to the clerk of the House. Very few MPs do that, and I'm sure it's fewer than actually have come across that situation. So again, the reflex of figuring out this is dangerous because I could unconsciously favor my brother-in-law, my grandmother, I don't know who, if I take a certain position in this committee or on this vote that is not about general application and involving millions of people, but a much smaller segment of the population. So that would be my answer.
Thank you. In my remaining time here, trying to get another whole other file here, I just want to touch base on the Vandenbelt report that you had done a couple of years ago, and this is of interest for me, having been in municipal politics and in the province of Ontario, for an example, municipal elections coming up this year, regarding endorsements and the use of title or in name and title in the endorsement or influence of a candidate in a municipal election. In Ms. Vandenbelt's situation, it was her spouse that was seeking office in the city of Ottawa. But can you just maybe talk a little bit more about that? Do you have any recommendations on our code review of clarifying a bit more? And I look, for example, where the line is drawn. Obviously, putting it in a householder or an official communication that's done by our members' operating budget for a municipal candidate would be inappropriate. But again, the social media aspect, or even going door to door for a candidate and saying, hi, I'm member of Parliament X for this riding and I'm out with candidate Y. Can you just talk a little bit about that to, again, try to get more of a black and white on this for members through evolving, not just municipal, but provincial or other elections? Thank you.
We are at time, Mr. Dion, but I will show some leniency so that you can provide us a response. And now that I'm interrupting, do you mind taking your boom just to between your nose and your top lip, just to see if that works? It seems online we're okay, but there is some glitch within the committee room not hearing you. So let's try that for your response.
And Madam Chair, before I appear again, I will ask for a new device. It could be the device that's a problem. So again, it's always dangerous to try to give general answers. The code, however, contains a provision which says very clearly, nothing in this code limits someone's ability to have political activities. So what I would suggest we do is maybe the member could contact me offline and we could discuss that. And we could also consider coming back to the committee with a general answer about members of Parliament supporting candidates at provincial and municipal elections. What are the boundaries? What's permissible? What's not permissible? We could do that if the committee so wishes.
Excellent. Thank you for your responses. Now we will go 5 minutes again to Mrs. Romanado.
Much, Madam Chair, and through you, I'd like to thank Mr. Dion for being here. Mr. Dion, in your executive summary, on page 1, you mention a broad spectrum of points of view have been taken into consideration in preparing this report. Did you interview any members of Parliament?
No, we didn't, Madam Chair. We took a passive approach to observations through the media, through anything on the web, and anything within the office.
Okay, thank you. And I think that's where you're seeing a lot of these questions coming out, because there's some confusion. When I was doing my MBA, every time I would ask my corporate finance teacher a question, he would say, well, it depends. And that's kind of what we're hearing from you is based on a specific case, it depends, right? Whether or not a gift is acceptable or if there is an actual conflict of interest. In recommendation 1, you are suggesting the book, the value of a gift under $30 not to be declared. So in terms of pratico-pratique, I don't know about other MPs, but often I get unsolicited gifts sent to me. So for instance, on the 25th of January, I received a book from somebody, don't know the person at all, but they signed a book and sent it to me. So when I flipped it over, it says it's valued at $28. So according to the code, I have, if I get past $200 from this specific individual in any given year, that is when I have to declare it within 60 days. However, I don't know, because it's January 25th that I received this book, if I'm going to get something else from this person. So in terms of the tracking all of this, there is no tool currently other than our own individual offices tracking gifts that we're receiving and logging them to be able to determine whether or not the person has passed that $200 threshold. So currently what I do is every month I just send it to your office, and I'm a frequent flyer. They always write me back thanking me. But is there a plan to have a tool in place for members of Parliament to be able to do this declaration, right away, so that way it's being calculated on your end? Because it is very labor intensive. And then subsequent to that, in terms of training, I agree that training is helpful, but given the labor intensity of tracking and logging all of this information, would it be possible to also perhaps think of training for staff members who are supporting us so that they can also assist in this regard?
Madam Chair, anything is possible given the appropriate resources, and it's for the House to decide what they would like my office to be doing. But at the current time, the obligation to declare, compute, determine when something has to be declared is with the MP, not with my office.
Okay, thank you. And I know that my colleague would appreciate some additional time, so I will turn it over to my colleague, Mr. Turnbull.
2 minutes, Mr. Turnbull.
Oh, thank you very much for your kindness. Great to get in for a couple of other questions here. Mr. Dion, through you, Madam Chair, I know in recommendation number 5, you stressed how important it is that members develop an understanding of the principles of the code, which I think is great. And you've talked numerous times in your remarks today about developing the reflex. I think what you were referring to often was developing the reflex of knowing members should be consulting your office. I'm kind of interested from a training perspective, how you propose to help members develop the reflex and judgment, the good judgment that's probably needed in order to come out with the right decision in many of these situations. There's a lot of gray area, and it's very difficult to determine what is the most appropriate course of action, and that's part and parcel of dealing with ethics and the types of roles that we have, where there's many competing interests at all time. And it's very situational. There's a lot of gray area. So how could the training incorporate elements that really help members of Parliament develop the judgment needed to make the right decisions in these situations?
Madam Chair, what we could do and have done on some occasions in the past is we could have case studies based on real life situation, while taking all the precautions, of course, to make sure that nobody would ever be able to guess who was involved. But I think real life is the best source of examples we can come up with of some people having made wise decisions to consult us and some people having made stupid decisions not to consult us. It's a good source. It's less abstract. It's because the possibilities there are millions of possibilities. But when you look at real life, it's more restricted than that. And we could come up with some good case real life examples of what to do and what not to do.
I definitely support that, Madam Chair, and I'll just ask one more question. And going back to my colleague, Ms. Sahoda's comments about the extended family and friends, I think I'm still concerned about that because I have no idea how I would ever fully comprehend the private interests of all of that extended network of people. Would have no knowledge of, you know, even some of my relatives' private interests in different things, where they invest, et cetera, et cetera. There are many aspects of that, and in some cases, the appearance of a conflict of interest can arise very easily by a situation and not really be merited in the sense that the member wouldn't even have known about it. So this is very highly problematic in my mind. Could you speak to that and how you would resolve that?
We are at time, but Mr. Dion?
The members by law already, there was an action taken recently in recent years by the House to amend the members by law to extend the definition of family. So all I'm proposing is that we adopt the same definition for the purposes of the code. And on relatives, yes, it's very difficult. It is the case already under the Conflict of Interest Act for non-elected officials and ministers, but it is difficult. There was the Leblanc report a couple of years ago where one of Mr. Leblanc's 61 cousins was involved in a fishing permit that the minister had granted. And I found that Mr. Leblanc was in breach of the Conflict of Interest Act because he had knowledge of that cousin and knowledge of his occupation. But it's possible that he would not have had knowledge, but he did have knowledge.
Thank you, Mr. Dion. Mr. Thérien, 2 minutes et demie pour vous. La parole.
Mr. Thérien, you have 2.5 minutes. So it's my turn. Thank you, Madam Chair. So earlier, Mr. Dion was saying that the pressure wasn't on him, but on the members of Parliament. And I was listening to Mr. Turnbull, who always asks excellent questions. And at the end, he said, well, I have a big family. I have cousins. Unintelligible. I don't know what my cousins do in life. And to remove pressure, I would say, would it be possible that the Ethics Commissioner, Mr. Dion, would be faced with such a situation, would assess the situation, and obviously he's not perfect, he's a human being, and he would think that, I think everything's fine, and that later he gives his approval to the situation, but later a journalist investigates this and find a problem, and then the MP finds themselves in a very unenviable situation. Is that possible? There's an article in the code that says if you ask for advice and you get advice, you're protected. So you are protected, and it doesn't protect you against the media. And obviously, because we provide the facts to the office, you have to present all the facts. The assessment is done on the facts, and there can be new facts that come out when a journalist starts looking at the situation. That's part of real life. Madam Chair, we take the facts that we have, we provide an assessment, an opinion to the MP who can use it to make a show of good faith, but it's possible that a journalist continues to investigate the situation and affects the person's reputation. So we have the agreement of the Ethics Commissioner, and what's possible, maybe we didn't provide the information properly, or there was no information available. But we can say, well, Commissioner, we gave the information in good faith, and in that way we can avoid popular sanction to a certain extent. Final question, sanctions. What are you going to impose as sanctions? Madam Chair, we don't impose any sanctions. We're here to talk about the code and not the law on the Act on Conflicts of Interest. Only the House can impose the sanctions, and that's never been done yet for a member who has contravened the code. Thank you very much, Mr. Dion. My pleasure. Madam Blaney, 2.5 minutes.
you, Madam Chair. And I guess my question through you to the Commissioner is, I guess I want some clarity. I listened to some of the responses, and one of the things that I think I heard, and I just want to confirm, is that as things change, and the world is changing quite rapidly all the time, what I think I heard you say is that you cannot say, hey, this might be a problem, everybody watch out for this. You have to wait till a Member of Parliament actually inquires. So I'm just wondering if you could clarify that, and if there is any process in place that if you, the Commissioner in their role, sees something that could become a problem for MPs, what that process is to alert us to it, if there is one.
So the code, Madam Chair, currently restricts me to, under subsection 26.2, to issue, it says the opinion, so I have to have an MP who asks me a question. I give an opinion. It is confidential, and it may only be made public with the written permission of the member. That's the first one. And number two, publication. It says the Commissioner is authorized to publish opinions for the guidance of members, provided that no details are included. So I cannot publish anything unless it comes out of a request for opinion made, an actual one made by an MP. So I cannot discuss hypothetical questions in public descriptions of what the code requires. So the mechanism is basically if I found that there was so a few years ago, I issued a bulletin on the interns, for instance. This arose out of a situation where an MP had sought our advice. It was fine. I was able to issue the bulletin on interns. I issued a bulletin on the provision by Enbridge of gas and barbecues to MPs for the annual picnic. Again, arose out of a question asked by an MP. I was authorized to issue it. But the code is such that each time Parliament is dissolved, everything disappears. I basically start from scratch each time a new session begins, or a new Parliament, a new legislature is formed. So anything that was in existence on August 15, 2021 has vanished. We start from scratch. And the code is designed.
So just to clarify, I know my time is almost up. That is what recommendation 6 is really about then.
Yeah. Yes.
Thank you.
Is that good clarification, Ms. Blaney?
Thank you. Yes, it is.
Thank you so much. And now 5 minutes to Mr. Calkins.
Who?
Calkins. Thank you.
Thank you very much, Madam Chair. And thank you to the Commissioner. I have just a few questions. I don't mean to put you in a hypothetical situation, but given the discussions that we've had here, I do have a few concerns. I want to follow up on something that Ms. Romanado brought up, her book that she received. Is there a difference, or would you perceive a difference if she keeps the book or doesn't keep the book? And do you receive a gift if you don't keep it, or if you do keep it? And how would you expect members of Parliament to quantify or qualify that for the purpose of meeting the threshold?
So, Madam Chair, you only receive a gift if you have failed to decline it. So if you keep the book, you have received the book. If you return it the morning after, you have not received the gift. The value of, there's nothing wrong about accepting a gift when it's acceptable. So it's for the MP to decide whether receiving this $28 book could be seen by a reasonable person who has the necessary facts to be given to her in order to influence, or whether it would have the effect of influencing her in her judgment in the future vis-a-vis the person who gave her the book. I doubt very much that a book worth $28 could do that with any MP. So I think it's perfectly fine to keep the book, and receiving gifts from the same source within a relatively short period of time of 12 months. Then you have to compile that and declare once you cross the line at $200. But it's perfectly fine to accept gifts when they're acceptable.
So I don't know at what point I, as an MP, accept something. Do I accept it when my staff member picks it up in the mailroom? Do I accept it when my staff member brings it through the threshold of my office door? Do I accept it when my staff member sets it upon my desk and it sits there for 3 months before I even acknowledge it? There are a lot of questions about this, and given the arbitrary nature of the $30 limit and the $200 limits, and I'm not going to argue your definition of arbitrary because there are always arbitrary things. I am worried, though, if your answers seem to indicate that I would have to return the book rather than just dispose of it if I chose to just throw it in the recycle bin. Have I kept the gift, and do I need to track that $28 in that particular instant from Mrs. Romanado? And if I get a subsequent book that I choose to keep for $28, now I've got a book that I've disposed of and a book that I've kept, the combined value of which would put me above a threshold, even though I didn't keep one of the books and I didn't return it. So, I don't want to get into I understand that the office has the ability to differentiate these things. We're all intelligent people. But I am concerned that if we go down too many of these rabbit holes, that we will find ourselves as reputable and honorable members of the House of Commons through no fault of our own and through no fault of you in the course of your duties, find ourselves in situations where we're answering ridiculous questions to reporters and others about our integrity, and I'm very much concerned about that. So I'll just leave that with you. I'm going to move on to the family portion, and I'm asking this question based on, I just don't know or I don't recall, but it would seem to me, as a member of Parliament that represents several thousand First Nations people, their definition of who they call family members is substantially different in their culture than my family definitions would be. And does the Act, I know this is about the code, but does the Act, the definition of the Act that you're asking to have put in the code account for that type of differentiation should a member of the First Nations community be elected to the House of Commons?
Madam Chair, the Act, my recollection is clearly the Act does not distinguish, and I guess the applicable family law definition currently in force in each province would apply.
Thank you, Commissioner.
I don't think any province has yet legislated to make any difference whether you're First Nations or not First Nations.
Thank you. Thank you so much, Commissioner. Madam Chair, through you, my next question would be,
it will be your last question.
If a member of Parliament in using digital media, social media, uses a number of hashtags or so on to say I was at a charitable event for this charity, or I was at an event for this business in my riding, or I was using this type of equipment that I typically use to do whatever I might do, and then ended up in the period post-employment as a member of Parliament working for one of those organizations, how would the Office of the Ethics Commissioner view the use? Would that be a furtherance? Would that be viewed as a furtherance of interest by using those hashtags and so on post parliamentary career?
My answer, Madam Chair, would be we would view it objectively in light of the specific facts of the situation. How many times, since when, how strongly, so on and so forth, would serve to determine whether there was an intent to position someone for life after Parliament.
Thank you, Mr. Dion. And now 5 minutes to Mr. Gerritsen. To you, the floor.
Thank you, Madam Chair. Mr. Dion, through you, Madam Chair, to Mr. Dion, my first question in reflection on what I've heard over the last hour and a half is I'm curious if you ever and your team ever stop and reflect on whether or not there's the possibility of over-bureaucratizing a process at the expense of accomplishing the objective. And, you know, I reflect back on what I've been hearing because I think of, you know, for example, I'll just go back to the example from Mr. Calkins where he talked about the book. And, you know, you said if you return it the next morning, it's not considered a gift. Well, what if I read it really fast and then returned it? Is it a gift? You know, you talked about the example of the milk lobbying organization giving a $175 painting. I personally have no interest in art. If they gave me $175 worth of chocolate milk, that would be a lot more valuable to me than a painting. You know, you talked about the commissioner weighing in on whether or not people were working 2 jobs and if that's appropriate. I can't think of a line of work where the individuals who are in these positions make the job the way that they do. I don't know 2 MPs who treat the job the exact same, in that this job is so unique that people make it what they make it for themselves and their constituents. And quite frankly, I'm the type of person that, I need 8 hours of sleep a night. I couldn't do 2 full-time jobs, but there are people out there that don't. I can't understand why we would put the responsibility in the hands of somebody else to determine if they're working too much. And then finally, the example of, you know, the family situation. And I can understand this, and I can understand my immediate family, but I talk to my brother 2 times a year, at Christmas and usually around his birthday. I'm from a small family, unlike a lot of what we've heard otherwise here. I don't feel comfortable asking him what his investments are. It's not something that, you know, I personally feel comfortable with. So I guess I'll just come back to asking you the question that was slightly rhetorical at the beginning, but I do mean it in all seriousness. Do you ever stop and reflect on whether or not the processes that are being put in place are being over-bureaucratized at the expense of accomplishing the end objective? Because when I was in municipal politics, it was so much more, a code of conduct was so much more based on principles than trying to define each and every single rule. And as demonstrated, I think, most eloquently by Mr. Calkins previously, it's very easy to drive a truck through the loopholes in these rules if somebody really wanted to. And and at the end of the day, it's those, you know, it should be based on somebody's principle. In my opinion, I'd love to hear your response, although I probably burned the whole 5 minutes, Madam Speaker.
There is a minute and a half. Mr. Dion?
No, we haven't really stopped, because the way this is managed, of course, the code is defined by the House, was defined by the House in 2004. My predecessor made numerous suggestions back in 2013, a few of which were kept in 2015. We apply the code. We don't write the code. We basically come up with processes in order to implement what the House has decided in the code. We try to make it as little bureaucratic as possible, but in spite of all our best efforts, there are some provisions which are quite require some bureaucracy in order to implement them. So that's my candid answer is we basically take what we have. It's like the police implementing existing laws. It's like my role is defined in the Parliament of Canada Act. My role is to assist the House in implementing the code, and I have the code I have. I didn't create the code. The code is there.
And I thank you for that, Mr. Through you, Madam Chair, to Mr. Dion. And I just wanted to add my words to the others that have said. Your office is by far one of the best in replying. They get back to me instantly when I email them. And I really do appreciate, through you, Madam Chair, to Mr. Dion, your openness and candor in having this discussion with us today.
Mr. Dion, do you want to compliment your team as well?
No, I would like, that's why exactly, I would like to thank every member who has made the observations about my office. They were all positive. I think they're well deserved. And I'd like to, of course, thank my team for making that happen.
So with that, that brings us to the end of our time here with you, Mr. Dion. So we would like to thank you and your team. There are a couple of outstanding items that the members have asked you to provide. So some of those details and data, if you could provide that through the clerk, we would appreciate that as we continue our review and study on this. Do you have any final comments?
Except to thank you, Madam Chair, and to reiterate the fact that I'm available at the simple call whenever you need me.
Excellent.
Thank you.
Please keep well and safe, and thank you for being here today.
Thank you.
With that, members, I know we were going to continue in camera, but we're running out of time, and I don't know how long that will take. There was an agenda that was circulated to subcommittee members, and all have responded to it. So, of course, we'll have to entertain what we're doing after the next few meetings. But if suitable, I do believe within this format, without going into details, we could approve the series of meetings that we have shared in that email. Any thoughts?
Madam Chair, if I could, we're in agreement with the calendar as proposed. I apologize for the delay with our subcommittee, but as good as circulated, and we will have a couple of busy weeks. So we're good with that, and we can proceed.
Thank you for that, Mr. Duncan. Monsieur Terrien, est-ce que vous avez des commentaires ou est-ce que vous êtes d'accord?
Mr. Terrien, do you have any comments or do you agree? Well, as I wrote earlier, we agree with this, no problem. And I must congratulate you for your efficiency. Thank you very much.
Madame
Ms. Blaney?
We're good. I sent an email response, so I'm fine with the calendar.
Excellent. Thank you. Mr. Turnbull?
Yep, our teams discussed the proposed schedule, and it looks great.
Excellent. With that, I will wish everyone a happy Thursday. I hope you all keep well and safe, and we will see you next week. Bonne journée. Merci à tous.